Welcome. Today we're going to talk about the 2021 new employment laws and what every business needs to know to stay out of trouble. We're going to start with leave laws. AB 1383, California Family Rights Act. This now applies to employers with 5 or more employees, where previously you had to have 50 or more employees to qualify. This repeals the California New Parent Leave Act, and it provides up to 12 work weeks of job-protected unpaid leave during any 12-month period. And this is to bond with a new child, to take care of yourself if you have a serious health condition or a family member with a serious health condition, or a qualifying exigency related to covered active duty or the call to covered active duty of an employee's spouse, domestic partner, child, or parent of the armed forces. It's also changed to an employer who employs both parents must grant up to 12 work weeks of leave to each parent to bond with a new child, where in the past it was 12 weeks total. The next bill is AB 2017, sick leave or kin care. It states that the designation of sick leave is at the sole discretion of the employee. So effectively means that at least half of an employee's annual allotted sick leave can be used towards kin care or for kin care purposes, but the employee has to make that designation. The next one is AB 2399, paid family leave, qualifying exigency. Paid family leave expands to include another covered category of participation in a qualifying exigency related to the active duty or call to active duty of an individual's spouse, domestic partner, child, or parent in the armed forces. The next and last one on this page is AB 2992, expanded protections for victims of crime or abuse. This applies to employers with 25 or more employees, and it expands the existing provisions to apply to employees who are victims of a crime or abuse for taking time off of work to obtain or attempt to obtain relief, which includes a temporary restraining order or other injunctive relief to help ensure the health and safety of the victim and their child. Now we move on to workplace safety. First one is AB 1963, mandated child abuse reporting for businesses that employ minors. This is designates your human resources professionals and your management level employees who work for a business that employs minors. They're considered mandated child abuse reporters. And those such people should be given mandated reporting training and written statement describing the obligations of being a mandated reporter. And again, this is your human resources professionals or your management level employees, only if you employ minors. And this is for employers with 5 or more employees. The next is SB 1159. This is the workers' compensation presumption. This creates a disputable presumption of workers' compensation coverage for employee illness or death resulting from COVID-19. On or after July 6th of 2020 through January 1st of 2023. Keeping in mind that these claims must be rejected within 30 to 45 days, not the usual 90 days. Otherwise, the injury is presumed compensable. This is going to require some notice to claims administrators. The next is going to be AB 1867, your paid sick leave, hand washing, and family mediation. This bill packs a bunch of unrelated laws into one bill, one being supplemental paid sick leave for employers with 500 or more employees nationwide. Another is now available to healthcare employees and emergency responders who were not provided the paid sick leave by their employers under FFCRA, which is the Family First Coronavirus Response Act. Food employee working in a food facility shall be permitted to wash their hands every 30 minutes or additionally as needed, and also requires the DFEH to create a small employer family leave mediation pilot program, which would authorize a small employer or the employee to request all parties to participate in mediation through the DFEH's Dispute Resolution Division. Last on this slide is AB 685, new reporting requirements for COVID-19 exposure. What this is for all employers, and it's notice and reporting obligations for COVID-19 workplace exposure. This allows the state to track your COVID-19 cases in your workplace more closely. It's contact tracing. Expands Cal OSHA's authority to issue stop work orders for workplaces that pose an imminent hazard relating to COVID-19, and requires notice in the event of a COVID-19 exposure in the workplace, including providing written notice within 1 business day to all employees who were at the work site within the infectious period who may have been exposed to the virus. Next, we'll talk about the new Cal OSHA regulations. This new regulation applies to all employers at this point, employees and places of employment, with the exception of workplaces with only 1 employee who do not contact with other people or do not have contact with other people, employees who work from home, and employees who are covered by aerosol transmissible diseases and regulation. The main requirement for this Cal OSHA regulations is that employers have to develop a CPP plan, so COVID prevention plan, as a standalone document, or you can incorporate it into your existing IIPP, so your injury, illness, and prevention plan, which is what most employers are required to have. Within the COVID prevention plan, it must do the following. It must communicate to employees on what your prevention procedures are. It needs to identify, evaluate, and correct COVID-19 hazards in the workplace. It needs to require physical distancing. It needs to require use of your facial coverings, use of engineering control, so that would include your PPE, implement procedures to investigate and respond to COVID-19 cases in the workplace, provide COVID-19 training to your employees, and provide testing to those who have been exposed in the workforce. And to make sure that if there are any major outbreaks, which are considered 3 or more individuals that live in different houses that work in the same space within a 2-week period, is considered a major outbreak. And you would need to give that information to your local health department and also Cal OSHA. At the bottom of this page, there is a link to OSHA's template for the CPP plan. Personnel Perspective has done significant work around this area, so if you need any further clarification or you need assistance with your plan, please reach out. We would love to assist. The next is minimum wage an hour. There's been a lot of minimum wage increases over the last few years. There is definitely one that just happened on the 1st, and it affected quite a few cities and counties. So if you are not aware of where you're at as far as the increase in minimum wage, make sure that you're paying attention to all of federal, state, county, and city minimum wage requirements. And below, there's a link to a list of different cities and counties that you can determine where you're at. More on wage and hour. The next being SB 973, pay data collection and reporting. So what this is, it requires California private employers who have 100 or more employees to submit a pay data report to the Department of Fair Employment and Housing, DFEH, by no later than March 31st, 2021, and annually thereafter. So you can model after your federal EEO-1 Component 2 collection forms. The next is AB 1947. So this extends the period to file a DLSE complaint and attorney's fees for whistleblower retaliation. So this extends the period of time employees have to file a complaint with the Division of Labor Standards Enforcement, so the DLSE. It went from 6 months to 1 year. It also allows the court to award reasonable attorney's fees to a plaintiff who successfully brings a whistleblower action. Next is AB 1864, whistleblowing protections. This prohibits adverse action against employees who have filed any proceeding under the Consumer Financial Protection Law. Next is AB 3372, employment taxes. This permits any notice or document required to terminate, modify, or release an earnings withholding order for taxes to be served by electronic transmission. Last on this page is AB 1066 for agricultural workers, wages, hours, and working conditions. What this one says is any employee who works in an agricultural occupation cannot work more than 8.5 hours in a day or 45 hours in a week without being paid time and a half for any overtime. Next is AB 2143, and this is a settlement agreement, no rehire provisions clarified. So this expands sexual harassment, sexual assault exceptions to also allow no rehire clause in situations where employment or the employer has determined the employee engaged in criminal conduct. And then AB 2147, conviction expungement for incarcerated individuals. What this is a bill allows certain individuals with criminal convictions who've been released from custody and completed the California Conservation Camp program to have their convictions expunged. This does not pertain to violent felonies or sex offenses of any kind. This bill was passed in the wake of our recent fires. So incarcerated individuals who have worked on the fire lines and have gone through the California Conservation Camp program, once they're released, is easier for them to retain employment in the firefighting area. That concludes the new bills for 2021. If you have any questions or need further clarification on anything, please reach out. Our contact information is below. My name is Amy Kanakis. I work for the Personnel Perspective as an HR consultant, and our information 707-576-7653. Give us a call and we can assist. Thank you. Have a great day.